Hello, I'm Cliff Ely. I'm a workers' compensation attorney in Colorado. My practice is limited to representing injured workers, and I've been doing that for 27 years. Today I'm talking about what are called Division Independent Medical Examinations, or Division IMEs. These are different than a regular independent medical exam, or IME. An IME is where the injured worker is examined by a non-treating doctor, usually at the request of the insurance carrier. Those exams usually have no binding effect. An IME might be used to influence the judge or treating physician. A division IME is different than that and usually has much more legal effect on your case. It's called the division IME because it's done through the Division of Workers' Compensation pursuant to the Workers' Compensation statute. It is most frequently used after the treating physician puts the injured worker at maximum medical improvement and gives him a rating. If either side contests the date of maximum medical improvement or the rating, they can ask for a division IME. The cost of the exam is usually $675 and is usually paid by the requesting party, but if the injured worker can't afford the exam, there is a procedure for getting the insurance company to pay for it. Frequently, an injured worker is put at maximum medical improvement, but he still has symptoms and restrictions and believes there's more that can be done. Usually, the only option in that case is to ask for a division IME. This is how it works. When an injured worker is placed at MMI, the insurance company usually has to file a final admission of liability. It will state the date of MMI and the rating that the treating doctor gave the injured worker. It will also state how much permanent disability the insurance company will pay for the permanent impairment rating. From the date the final admission is filed, the injured worker has 30 days to file an objection to the final admission and to file a notice and proposal. The notice and proposal is notice to the insurance company that you want a division IME. On the notice and proposal, you need to list 2 or 3 doctors that you will agree to for the division IME. If the parties can't agree on a doctor, then the insurance carrier files a document called the Notice of Failed Independent Medical Examination Negotiation. This tells the Division of Workers' Comp that the parties can't agree on a doctor, and when that is received, the Division of Workers' Compensation sends out a list of 3 doctors which they pick randomly from their list of potential division IME doctors. None of these doctors can have treated the worker before. Each side crosses off one doctor and the injured worker goes to the doctor that remains. The requesting party then files the application for division independent medical examination, which lists the issues and the parts of the body that require a rating. The insurance company then sends all of the medical records to the division IME doctor, and the doctor does the exam and issues a report. This usually takes about 3 months. What that doctor says regarding the date of maximum medical improvement and the rating is binding on the parties. The only way to get around that opinion is to go to a hearing and show by clear and convincing evidence that the division IME doctor is wrong. So if the division IME doctor says that you're not at MMI, then you'll continue to get treatment. And if you were on temporary disability benefits that were cut off because you were placed at MMI, then those should start up again from the date they were cut off. If the division IME doctor says that you're at MMI and that you have a higher or lower disability rating, then your permanent disability benefits will be adjusted accordingly. The rating given by the division IME doctors are frequently higher than the treating physician's ratings, but they can be lower or the same. In most cases, though, it's worth having a division IME. Either side can contest the division IME doctor's opinion, but again, you have to show by clear and convincing evidence that the doctor is wrong. And clear and convincing means that it is highly probable that the doctor is incorrect. This is a more difficult standard than a preponderance of the evidence, which is usually required in workers' compensation proceedings. To get clear and convincing evidence, you really have to hit it out of the park. It has to be obvious that the doctor is wrong, and this is usually very difficult to do, so you want to win with the division IME doctor and get a good opinion from him. The division IME doctor can also give an opinion as to what parts of the body were injured, but the doctor's opinion about other things, such as restrictions, for example, they're not binding. Just MMI, the permanent impairment rating, and the extent of the injuries. There are some situations where a division IME is not needed and you can go straight to a hearing. If you get an extremity rating, which are for the arm or leg or foot or hands, and you think it should be higher, you can go right to the hearing with your evidence, usually with the evidence from another doctor. You don't need to do a division IME. If you got an extremity rating and you think it should be a whole person, like for example a shoulder, where it can be rated either as part of the arm, which is an extremity, or part of the torso as a whole person, you can go right to hearing, but you'll be limited to the amount that the extremity rating converts to a whole person. You won't be able to go higher than that because you didn't get a division IME. Also, if two authorized treating physicians disagree on MMI or the disability rating, you don't need to do a division IME. You can go to hearing and try to prove that you're not at MMI or that the higher rating is correct. You can do that because two authorized treating physicians disagree, but remember, without the division IME, you can get no higher than the highest rating that a treating doctor gave you. The insurance company can also ask for a division IME. They have to do that within 30 days of getting the MMI report and the rating from the treating doctor. If they don't, they have to file a final admission based upon that doctor's opinion, and then of course you would have the option of objecting and asking for a division IME. As you probably figured out, who you get for the division IME doctor is very important. Don't go forward with the division IME without getting the advice of an experienced workers' compensation attorney. They've been through this many times. They know who the doctors are and which doctors are more favorable to injured workers. Do not agree on a doctor with the insurance company unless you have at least gotten the advice of an experienced workers' compensation attorney. You won't know who these doctors are. The adjuster will know, and she'll probably send you to her favorite doctor. If you agree to that doctor, you could get a very unfavorable opinion that will be difficult, if not impossible, to overcome. So if you haven't already, you should always contact an attorney when your treating doctor says you're at maximum medical improvement. Don't go through this process alone. It's complicated and it's hazardous unless you're very familiar with the law and the doctors. If you have any questions about your rating, the division IME process, or any other aspect of your workers' compensation case, call me. I'd be happy to provide a consultation at no charge.